All right, guys. Well, guess what? No intro tonight because we have breaking news. Tonight, we're going to be joined shortly by Attorney Chris Kachouroff, who represents Harrison Floyd, who's one of the defendants in the Fani Willis RICO indictment here in Fulton County, Georgia. And he's going to be discussing the latest developments in that case and anything else that he might want to get into or wherever the conversation takes us related to Harrison Floyd. But before we get into that, if you've seen my Twitter feed, and I want to hopefully people will start getting in here. I'm going to wait just a moment before I bring this up. But if you watch my Twitter feed, you've seen that the breaking news is that former paramour, Fani Willis, Nathan Wade, has been accused by his wife, because he is not yet divorced, his wife in the pending divorce case. He's been accused of essentially failing to honor his agreement. Now, if you remember, there was a temporary agreement that governed the relationship of the parties while this case, the divorce case, worked its way through the court system. The temporary order covers things like financial obligations, whether or not people have to pay medical bills or other types of support. And the remedy available to someone if the other side doesn't live up to their end of the bargain, so to speak, is you have to ask the judge to enforce the order. And that's called a motion or an application for contempt. So I want to go ahead and let's go ahead and bring this up. All right, here you go. We have a defendant's application for contempt. And what we have is the defendant, Jocelyn Wade, Mrs. Wade. She has filed her verified, that means under oath, application for a citation of contempt against the plaintiff, Nathan Wade. And in support, she's going to show the court a number of things. And I won't read this verbatim, but basically she refers to January of this year, when the Judge Henry Thompson in the Cobb Superior Court, Judge Thompson signed this temporary consent order, and it was approved by the court. It was agreed apparently by the parties that the agreement would not be filed with the court, so it's not public record, but it nevertheless is binding on the parties. It will be public record presumably at some point, just not right now, but it is binding on the parties. And it says it would not be disseminated unless there was an enforcement issue. Now, the only thing I can take from this is that some people did not want the agreement to be made public. They didn't want everybody to know what was in it, what kind of money anybody was making, or what kind of money people were ordered to pay. But now Mrs. Wade says there is an enforcement issue. In other words, she's saying he's not done certain things. And I'm going to get into that in just a minute. But it seems to me that if you're holding this, the public nature of this agreement, if you're holding that over somebody's head, that would be an incentive for someone like perhaps a Nathan Wade. That would be an incentive for him to comply, because presumably it's Nathan Wade that doesn't want the terms of this made public. I'm guessing that's speculation, but I do think it's a reasonable inference to draw from the facts and circumstances. So I'm going to go ahead and get into all this. But before I do that, I do want to go ahead and bring in my guest tonight, which is Chris Kachouroff, who is the attorney for Harrison Floyd in the RICO case. He's an attorney. He's got a lot of experience in this, and I thought it might be helpful. So let's welcome Chris. How are you, buddy?
Hi, my mic is unmuted.
Chris, can you?
Yeah, I got you now.
Okay. Can you hear me? Okay.
Yeah, I can hear you fine.
Buddy. How are you, sir?
I'm doing well. Busy.
All right. So go ahead and introduce yourself to everyone while we're waiting on a few more folks to join in here.
My name is Chris Kachouroff. I am a trial lawyer. I've been practicing for about 24 years now. I'm a Virginia lawyer, but I do have gun and will travel to different states. I'm teamed up with local Georgia counsel Todd Harding, and we are Harrison Floyd's attorneys. I met Harrison Floyd up.
Yeah, go ahead.
Now, I'm just going to say I came across, you asked me once before, how did I get to Georgia? So I met Harrison Floyd up in Maryland, and that's how we became acquainted with each other. So,
all right. So when you represent someone not a member of the bar in the state where you want to represent them, and you don't have a license in Georgia, just like I don't have one in Virginia, how do you go about representing someone in a case out of state when you don't have a law license in that particular state?
you have to apply for admission pro hoc vice, which is for the occasion. And you typically courts allow, we have this fancy word called comedy, where we, not as comedy as in ha ha, but a little bit of politeness, where we allow foreign attorneys to come in just for a case or two. If you can't abuse the privilege, but you get permission from a local court, and when you do, you can practice in that one case. And so that's what I did for Harrison's case. I could have applied for full admission to Georgia, and which, by the way, I'm considering, but we'll see.
Well, yeah. So it's comity, COMITY, I think is, and people like me who speak, Georgian and Southern and redneck, it's hard sometimes for people to distinguish what we say. The other day I used the word precedent, and some people thought I was saying president because there's a former president involved in the Fulton County case. But I tend to speak quickly, and I apologize, but sometimes it's hard to distinguish when we're talking about these words, particularly when we have our accent. So y'all just bear with me. All right. So look, let's get back into this before we get into everything, because there's a lot to break down regarding Harrison Floyd and what has happened and what's going to happen. So let's talk about this contempt, and you can just chime in here however you wish. But picking back up where we left off, here in page 2, it says the temporary agreement states as follows. Now here they're literally laying out some of the language of it in quotation. So this part, this is part of what they wanted to keep secret, or at least not public. Plaintiff will pay, that's Nathan Wade, he will pay all uncovered medical expenses for his wife, apart from any elective cosmetic procedures, until further order of the court. Plaintiff, that's Wade, will additionally pay routine dental and vision care with a cap for those items of $500 a year. The defendant will forward, that's the wife, because remember, Nathan Wade sued his wife, so that makes her the defendant. She will forward invoices to the plaintiff, who will pay the same instanter. This is a fancy legal word. It just means right away. He will pay the same right away to medical provider directly, or make other arrangements with the provider. If the defendant's provider requires immediate payment at the time of service, then he, Nathan Wade, will be notified by Mrs. Wade, and the plaintiff, that's Nathan, shall arrange for payment instanter. That means right away to the provider, and plaintiff to be provided with receipts, etc., from the defendant if they're not sent directly by the provider. And the defendant shall file claims with the insurance company and shall forward any monies to the plaintiff upon receipt. In other words, whatever's not covered by insurance, and that sort of thing, he's supposed to pay. That's how I read it. Chris, do you see it that way?
Yeah, I do. And just for your viewers, just because somebody's a plaintiff, Chris, and somebody,
you still with me, buddy? Do
I'm here.
Do you see it that way? I mean, do you read it that way? He's supposed to basically pay. Yeah, I got you. He's supposed to pay the medical bills that are not covered by insurance. Is that about the size of this?
Yeah, that's right. I mean, that's exactly right. Yeah. Can you hear me?
The defendant urgently requires medical procedures. Yeah. The defendant urgently requires medical procedures. I got you, buddy. Loud and clear. Namely an endoscopy, a colonoscopy, and an ultrasound to what she says is severe physical symptoms she has been enduring. And we don't know what these are, of course. That's what the allegation is about. And it's obviously severe enough that she has filed a contempt. These symptoms have significantly impacted her ability to consume most foods, leading to substantial weight loss, notwithstanding her upon information and belief. Now, that's what when you hear lawyers say that, they're probably referring to something their client told them, or at least some third party. But in this case, it's probably information the lawyer got from the client, because that's how the lawyer has to know what's going on before they can file something with the court complaining about it. So upon information and belief, her condition is worsening and is delaying these diagnostic procedures. And delaying these procedures may necessitate emergency intervention unnecessarily. The defendant has notified the plaintiff of the urgent necessity of these medical procedures in the amount of $4,400. Now, let me pause right here. I seem to remember that over the last couple of years, the plaintiff in this divorce case was paid upwards of $700,000 for work as a special prosecutor in the Trump RICO case here in Fulton County, pursuant to a no bid contract awarded by District Attorney Fani Willis. So, I mean, Chris, I'm interested to see if you have a take on that. $4,400 seems like minuscule when you're making that kind of cash.
Yeah, I would say, Phil, you're absolutely right. I mean, one of the trips, I guess, to the Virgin Islands or wherever they went, I'm sure that was probably $4,400. So, I think that's at a minimum, he should be able to come up with that no problem, unless he's been spending the money on Fannie.
Well, the $4,400 just, it's a lot of money. Don't get me wrong, but relatively speaking, it seems like it's peanuts compared to what all he was apparently making. Yeah. In any event, says despite a direct request for him to pay these things, an additional demand so apparently a direct request from Mrs. Wade to Mr. Wade, then an additional demand from the lawyer. This says that plaintiff has failed and neglected to fulfill his obligation under the temporary order to cover these necessary health care costs. Instead, he has instructed defendant to make the payment herself with an assurance of reimbursement. Okay. So he says, you got to pay it yourself, and I promise I'll pay you back. All right. Well, that's it's not apparently what the temporary order calls for. It says, ironically, the defendant finds herself unable to fulfill the prepayment obligation despite not being legally obligated to do so, due to the actions of the plaintiff. On the day immediately following the entry of the order dated January 30th, plaintiff informed the party's daughter, an upperclassman in college, with hopes of entering medical school in the near future, that he would discontinue payment of her rent and her living expenses, instructing her to get the money from your mother. Wow. That is quite the allegation, Chris.
Well, Phil, you're being a little harsh on Wade. He doesn't have a job. I mean, come on. Change of circumstances is always a defense to these things in a domestic case. But look, I mean, if this is true, I mean, telling your daughter, I'm going to stop paying for these things and you need to get the money from your mother. I mean, come on. It is noteworthy that the daughter's rent was due that very day, demonstrating the defendant's unwavering commitment to her children's education and future. She promptly covered her daughter's rent payment and has continued to do so every month thereafter, with the money she receives in spousal support awarded to her under the temporary order. Additional, plaintiff has punitively reneged on his commitment to cover the daughter's MCAT expenses, that being the entrance exam to medical schools. Okay, and let's see, this sounds like it might be getting worse. The party's son is currently in Europe pursuing a career as a pro soccer player. Despite the plaintiff executing a verified affidavit to the country of Spain, affirming a financial responsibility for his son's expenses for visa purposes, he subsequently informed his son, after the temporary order was entered, that he would no longer be providing support for him either, directing the son to get the money from your mother. When was that temporary order issued? Do you remember?
Yeah, this says it was on January 30th, 2024.
So this is before the judge even ruled that he was out.
Oh yeah, this was back. According to this, the allegation here is that, shortly after the entry of the temporary order, he basically cut the children off and said, "You're going to have to get the money from your mom."
Yeah, and this is before he was even out of the case. I mean, he's still making money at this point.
$250 an hour, right? Yeah. And that's just on. And look, he's
a day, by the way,
just on the case. What's that?
Sometimes he billed 24 hours a day.
We saw that. So in response, the defendant, unwilling to leave their son in a foreign country stranded, looks like she diverted some of the spousal support there as well. Plaintiff's sudden cessation of support for the party's children has placed the defendant in a dire financial situation, resulting in a monthly income of less than $1,000. Additionally, defendant cannot work due to her poor health. As a consequence, she finds herself in a worse financial condition than she was prior to the entry of the consent order. She acknowledges that there is no jurisdiction over the expenses of the party's adult children. However, she provides this information to illustrate the pressing need to be addressed on the court's next available calendar, as the defendant lacks the financial means to cover the medical procedure prepayment and then to await payment from Nathan Wade. Lastly, the plaintiff was to pay a total amount of $15,000 to Frazier Dieter, the firm employing the defendant's financial expert, Beth Garrett. And the plaintiff personally provided a cashier's check made payable to Dieter in that amount. It says FedEx lost the package. Now, parenthetically, this is believable to me because today FedEx failed to deliver a package that I've been waiting on and nobody knows where it is. So this is kind of believable. But in any event, it says FedEx lost the package. Defendant's counsel requested plaintiff's counsel to have plaintiff address this with the bank. The plaintiff had contact with the bank, who wrote a letter stating that after they did a deep dive, it would be 90 days until they can reissue the check. I thought you could just stop payment on a check, Chris.
Yeah, that's what I thought.
And the defendant seeks an order requiring the plaintiff to take whatever steps are necessary to ensure that the cashier's check was reissued. All right. So the rest of this is legalese. This is things asking for, well, this is worth talking about. What she's asking for is for those of you who are reading it, may as well explain some of the legalese. Make him respond in 5 days, which is a pretty short response time. Issue a rule nisi. This is legalese. This is Latin. Basically, it's an order scheduling a hearing on the next available calendar. Issue a citation of contempt against plaintiff Nathan Wade and find his conduct to be in willful violation of the temporary order. Punish him with incarceration, ordering a purge in the amount of $4,400. So let's get into what this means. Okay, so we've got the temporary order, which is again the order that governs the relationship of the parties. What do they owe each other in terms of finances? What do they owe each other in terms of any other obligations? Things that govern the conduct and the relationship of the parties while the divorce is pending. Because once the divorce is over, there's going to be a final order of and a judgment of divorce that governs their parties on a permanent basis. So this is just temporary, but it does apparently require Nathan Wade to take care of some financial things as it pertains to his wife. Right. Now, when you ask a judge in a civil case to throw somebody in jail in the context of a civil contempt, it's worth noting that judges that's kind of the last resort, but the lawyers have to ask for it because it is one of the remedies when somebody if they don't follow a court order, the judge has to punish them or take some corrective action. It's kind of like in a certain case we know of in Fulton County, where maybe a judge says to the prosecutor, you're not supposed to be talking out of the court about defendants, calling their lawyers racist, calling them racist, and then people continue to do the same thing. This is kind of like that, but this is in the context of a divorce. So the wife is saying that Nathan Wade has not done what he's supposed to do. She's saying, Judge, I want you to make him do it. And simply by filing this, hopefully, the lawyer is thinking this is going to get his attention and make him pay this money and get him to do what he's supposed to do pursuant to this agreement that we had. And in the alternative, if he still won't do it, they're going to say, look, you need to throw him in the jail, put him in the jail with what's called a purge. A purge is literally the keys to the jailhouse door. It is what he has to do to get himself out of jail. So to purge yourself of contempt when you're in jail, it's typically paying a certain amount of money. So nobody wants to go to jail. that is sort of the hammer that's being held over his head. They're asking the judge to essentially make him do what he's supposed to do according to the agreement, and if he doesn't do it, throw him in jail. Do you see it another way, Chris?
No, I don't. We call it a rule to show cause, rule nisi or nici. Same thing in Virginia.
All right. So what do you make of these allegations? What do you make of the allegation that he's essentially, according to the pleading, he's essentially cut his children off? So it maybe is a way to spite his mother. What do you make of that?
I think he's irritated because I don't think he believed, perhaps in his own concept of reality, that his wife was going to cooperate with the defendants in the biggest trial of his life, perhaps the biggest case of his life. Doesn't really know if she did, but probably suspects that she did. But I think that, his what he's doing is he's being vindictive, and all these excuses like the deep dive on the bank account. Come on, everybody here has had to stop a check, or it's a pain in the neck. I know, but they can do a deep dive to find out about it, but he can do a quick dive to cut a new check. That doesn't take that long.
I wouldn't think so. I don't. I mean, obviously, I don't know. It doesn't seem plausible to me that it takes 90 days to reissue a cashier's check. And look, and even if it does, pull the money from somewhere else.
You got cash, right? You got cash?
Maybe it's in the cabin. Yeah,
it's in the safe.
All right. So anyway, so this is the breaking news. And yes, folks who are asking, we're going to get into Harrison Floyd here in just a moment. But I did want to at least cover this because it is certainly related to the things that we've been talking about on this channel and elsewhere, because up until very recently, Nathan Wade was one of the key players in the Fani Willis, I call it the Fani Willis Fiasco, the RICO case in Fulton County. And of course, he was booted off of that team. The judge gave him a choice. One of you's got to go, right? So shortly after his order, she left, but the issue of her disqualification still is pending because there is an appeal. There's what we call a discretionary appeal. There's an application pending right now before the Georgia Court of Appeals. And it's a two-step process. You got to ask the judge for permission to do a pretrial appeal in most circumstances. You've got to then, if the judge approves it, you got to get the Court of Appeals to say yes. Now that's a good segue to get into Harrison Floyd. And Harrison is one of the defendants in this case. His lawyer, Chris Kachouroff, is with us, and he's going to tell us more about his appeal and what's going on. But before we do that, I want to share with you guys just a little bit of background here. So let's go ahead and look at what the first news was we saw about Harrison Floyd early in this case.
As investigations continue tonight into conditions at the Fulton County Jail less than 4 hours ago, the only Georgia Trump co-defendant to spend time at the jail received a $100,000 bond, but he's going to stay in jail at least for another night.
So at this hour, supporters of Harrison Floyd have started collecting donations online, referring to him as a political prisoner. They have now raised almost $300,000 to pay for his bond and his legal fees. 11 Live's Don White is also live tonight from the Fulton County Jail with the breaking details. Don.
Ron and Jennifer, Harrison Floyd's lawyers told me earlier today they expected him to walk out of the doors here in the early evening, but now they say he is going to remain here until 9 a.m. tomorrow morning. Now, his lawyers, they stayed inside of the jail until about 10 p.m. trying to work out details of his bond, but they say they were not able to do that. Fulton County Superior Court Judge Scott McAfee signed the bond order this afternoon. Another judge denied bond on Friday, saying Floyd was a flight risk due to an open federal case in Maryland for allegedly assaulting an FBI agent. Floyd is the former director of Black Voices for Trump. In Fulton County, he's facing charges related to the alleged harassment of county elections worker Ruby Freeman after Georgia's 2020 presidential election. Fulton County District Attorney Fani Willis' spokesperson said Floyd never worked out a consent bond like the other defendants, that is before turning himself in. And arraignments for all 19 co-defendants, including former President Donald Trump, are scheduled for September 6th.
All right. So this was our first introduction. Those of us who had following the case, we didn't necessarily know a lot about Harrison Floyd until we learned that unlike everybody else who was indicted, he got stuck in the bed bug infested hellhole known as the Fulton County Jail. Chris, what happened?
Well, we were up in Maryland, and his family was getting repeated harassment from Fulton County, demanding to know where he was and what he was doing. And they said they knew what kind of person he was. Now, for your viewers, there's another parallel case going on in Maryland. It's a federal case now. It had been a state case, but two FBI agents who worked for the J6 committee, or I'm sorry, Jack Smith, they were trying to serve a subpoena on him and didn't identify themselves. And there's an allegation that Harrison engaged in an altercation with them. It's not true, and the facts are, that case is pretty interesting in and of itself, and I'm glad to talk about it with your folks if they want.
Yeah, so let me pause there. Is that in that news clip, there was a reference to initially he was denied bond by some, I presume, some magistrate judge. And
he was denied bond in Fulton County. A magistrate down there who said he was a flight risk. Now get this. The guy turns himself in voluntarily, and he's a flight risk. I mean, I don't know how she could.
Yeah, and part of it was on the basis of that open case, which is the one you referred to just now. So give us the thumbnail sketch of that case. What is that case about?
That case is fascinating. He was holding his 2-year-old daughter. He was walking upstairs to his apartment, had to get through a secured door with a gate key. He swipes the gate key, and these two individuals follow him in and telling him they want to talk to him. And he said, I'm not interested in talking to you. I don't know who you people are. And they said, well, we want to discuss some stuff with you. And he kept walking up. He said, there's 2 white guys, Chris. I don't know who they are. I got my 2-year-old daughter, and they're following me. And so he starts to go up the stairs, and he said he felt like that they were pulling on him or tugging on him. And he didn't fight. He just literally shoved off and went upstairs to his room or his house and put his daughter in. And as he opened the door, these 2 people threw paperwork in the door and said, you're served. And it turned out to be a subpoena for Jack Smith. Well, he got angry because he felt that they were rude, and they followed him into the inside of his condo area without permission, by the way. And he said, they told him that they were FBI agents. He said, you never even showed me a badge. I don't know who you people are. And he was mad, and, he lost his cool. He was cursing a little bit. Probably not the best look in terms of losing one's temper. But at the end of the day, it's clear from the tapes that he kept telling them, you haven't identified yourself. I don't know who you are. And so they said, look, we're leaving. We can show you our badges, but we're leaving. And one of them flashed him a gun, and he backed off, and they left. Well,
they pulled a gun during the service of a subpoena.
They didn't pull the weapon. They just flashed him.
Okay.
Codicide. And he said he never saw any identification on them. They never showed it to him. So he was upset, and he went ahead and called the local police department. The local police department takes the report. It's all captured on audio. You can probably find it on the web. And 8 hours later, the local police department comes to his apartment with several other officers, and they arrest him. And they charge as battery on a police officer. Now,
the local police did that?
The local police did that for the FBI agents who never made the report. Harrison is the one that called. And so what ends up happening is the day before the hearing in state court, it gets dismissed, and the federal court, the Federal Department of Justice picks it up and indicts him on a federal charge. I think it's bogus. I think it's a tribal case. I'm sad to hear that law enforcement. I used to be a police officer. I was a police officer for 3 years. And I promise you, if you ever touch somebody, if you touch, as a cop, if somebody laid hands on you, would you walk away and not do anything? Of course not. You'd call backup, you'd hook him.
Well, I've also served a lot of subpoenas, and I know that, all you got to do is either hand it to them. If they don't want to take it, you can literally lay it at their feet, and that's it. But I also know, I learned this in the police academy, and people, I'm sure I learned it before, but it's just not taught anymore. But you have a right to remain silent. You don't have to talk.
That's right.
You don't have to say anything. And they can't just walk in. A subpoena doesn't give them the right to come into somebody's residence, does it?
No. I mean, it was we call it curtilage, right? It's a safety, it's a security door that allows you to get entrance into the stairs of the complex. But you have to have a code, a swipe card, whatever you would call them, a CAT card, in order to get in, a security card. And so they must have stuck their foot in before the door closed so they could gain access. They followed him up the stairs.
All right. So back to Fulton County. He's turned himself in.
All right. He's on probation for the federal. I'm not probation. I'm sorry. Pretrial. Yeah. Pretrial release. And he has to report to a probation officer. And so he hears about the Fulton thing. We had no knowledge that he would be indicted in Georgia. And he said to me, I'm going down there. And I said, okay, well, you need to work out bond. And he said, it's not going to be an issue. I'm going to turn myself in voluntarily. I'll get a bond. I hear everybody's getting a bond. Now, he goes down there, and that's when he appears before the magistrate in Georgia, and he was denied bond because she said he was a flight risk. And my understanding is now that they rubber stamped those particular orders. It's sad. She didn't make any independent determination of the individual who drove personally all the way down from Maryland.
Well, I can tell you by way of just sort of informational background, what happens, and I'm sure you know this, but a lot of folks watching may not. What happens is there's an indictment. If there's a lot of times most of the time, the indictment follows the issuance of an arrest warrant. But in this case, the indictment came first. Now, when that indictment was filed, it would have triggered what's called a no arrest bench warrant. And typically on felony indictments, there is no bond that's predetermined, like there might be on an arrest warrant. And so they have to go in front of a magistrate within a day or two of being arrested, or in this case, turning himself in. The magistrate is not a superior court judge. It is a lower court, and they're oftentimes part-timers, but sometimes they're full-time judges. They have a courtroom at the Fulton County Jail. People come in, they appear in front of that magistrate. They're in handcuffs, they're in leg irons, probably in jail clothes. There might be a public defender. Sometimes you have a private attorney there. If you know in advance, you're going to have to turn yourself in. And then what happens is somebody has prepared for the judge a rap sheet, which is a computer printout called the GCIC. It stands for Georgia Crime Information Center, but there's also the federal counterpart, the NCIC, the National Crime Information Center. It's literally a printout that has it's called a cycle. Every time someone's arrested, it generates something called a cycle. So they don't look at what the results are of any of they just look at the number of cycles. In other words, it doesn't matter if somebody's not been convicted. It doesn't oftentimes matter if they've had charges dismissed even. All they really look at is the charges, and you're presumed innocent. The charges, arguably don't mean much of anything. But so apparently what I hear you telling me, please correct me if I'm wrong, this magistrate saw this open case and said that he or she believed that he was a flight risk and or a danger to the community or something along those lines, simply because of this open, unproven case. Is that right?
That's right. That's exactly right. Didn't even make a determination, or it didn't even consider the fact that he brought himself in and turned himself in. I mean, that should speak volumes for any magistrate, but as I understand it, they rubber stamp it. Let me just point out something for your viewers. Harrison would tell you that a lot of good workers in the Fulton County Jail, a lot of the bailiffs and the jailers there are good people, and he was very, very happy with the way that they tried to take care of him. He said the conditions there are awful. While he was there, I mean, there are people, I think you all know from Georgia, they've got people there that have died from bed bugs.
Yeah, that's true. We could do another entire discussion about that. But yeah, they do. That's been in recent news that literally somebody died by a bed bug infestation. It was a guy with mental health problems that really shouldn't have been in jail anyway, but was stuck. His case wasn't being processed by prosecutors through the court system, or it wasn't being pushed by anyone. And then lo and behold, he turns up dead, sadly. And it's my understanding that particular case triggered a federal sort of investigation by the DOJ into the conditions at the Fulton County Jail. But this was the jail where all of these defendants were having to report to, and they all turned themselves in voluntarily. But apparently, because Harrison Floyd did not yet have you or some other lawyer retained, and obviously you're not licensed in Georgia. You had to go through a process to get permission from the judge. We're going to get back into that in a second. But he turned himself in, and I guess he assumed that he would get a bond like everybody else.
That's right. And when he did that, obviously a little bit of political pressure mounted because Fani was going after him, and she, I guess, felt the heat and sent a couple of her minions over there, and they asked him if he wanted a bond. He said he did, and they said, sign here. And he said, can I have my lawyer look at this? And they abruptly turned and walked away. By the way, Fani did reach out to us, my colleague, one of my colleagues in Maryland, and was rude and abrupt with him on the phone. And he was dealing with the Maryland case. I was dealing with the Georgia case. And she ended up recording him. You know, Maryland is a one-party state. I mean, a two-party state. Both parties have to consent. I'm sorry.
So are you saying that she illegally recorded a phone call?
Oh yeah, it's a felony in Maryland. I believe she committed a felony. There's some dispute about what law applies. Is it Georgia or Maryland? But since she reached into Maryland and recorded a call surreptitiously of another attorney, I don't know how you would feel about that, Phil. But if an attorney's recording me, I'd be pretty upset.
No, you're right, and that's quite. Look, illegal or not, it's certainly unprofessional, and it's not the kind of lawyers don't need to behave that way with respect to how we interact with one another, even when we're opposing counsel and it's an adversarial relationship. There ought to be some professionalism and decorum, and I think, in my opinion, that's kind of below the pale. But all right, so how long did it take you to get him out, and what kind of bond were you able to negotiate it? Because I'm curious to know if you got a better bond than what they tried to get him to sign initially.
Well, from all the stories that I'd heard, my goal was to get him out of Fulton as quickly as I could. And but my understanding is that he was offered basically the same bond as everybody else. I could have had him out 3 or 4 days earlier, but in any event, it didn't happen. So.
All right, so he's out. That's good news. All right, so tell us about. You've got this issue now, and we're gonna part of what you're here for is to talk about this appeal. You filed a motion asking the judge to dismiss the indictment, and this is the one, I guess, it pertains to the election board. I saw a comment. This is from Coco's talking about there's a hearing that she sent with McDougal on the election board saying it was more votes. So this is all kind of related. I don't know that that's what he said, but this is related to your motion has to do with that election board, right? So tell us what the motion was about and why you think the judge should have dismissed it.
So in Georgia, what the General Assembly has done is to pass a legislative scheme to have oversight of the administration's irregularities and violations of election laws. And they've done that scheme when I say scheme, I don't mean that in a nefarious or an evil sense. What I mean is they've set up a structure where they have a board. It's called the State Election Board. And the State Election Board is comprised, it's supposed to be nonpartisan, although you have partisan members. And what they do is their job is to oversee elections because they don't want the local prosecutors going after their opponents. They don't want local petty prosecutions going on of political opponents, period. And I think that's clear from the language. And so we argued that language in the statute is pretty clear. It's straightforward. It says that the State Election Board will review and determine, if necessary and advisable, whether a, quote, further prosecution should happen. And if they deem that it should happen, their job is to refer it out to the Attorney General or to the appropriate district attorney. Now, what she did was she applied for an investigative grand jury, a special grand jury, that would look at the administration and the irregularities of the presidential election in 2020. But she didn't get a referral from the State Election Board. She just went ahead and did it herself because she said everybody was compromised.
Have you seen I guess it's some social media posts from Willis herself it may have been the day of or right after the election, asking basically whether or not, wonder what kind of shenanigans have been going on or something along those lines in the vote count, where she herself raised questions about it. Have you seen that?
Oh, I haven't seen that. No.
All right, I'm gonna see if I can find it. I'll send it to you. It's out there. I'm sure some folks in the chat are familiar with it as well. It's been widely posted on the internet, which of course is forever. All right, so the election board did not make this referral, and you and I were talking a little bit before we went live about this particular issue. And let me set this up. in, every state in the union, Georgia being no exception, has a law that allows people to file a lawsuit challenging an election, right? And it's a civil case. The law actually contemplates that there might be a dispute over who wins an election. And the law says, okay, if that's the case, you can file this kind of lawsuit. And that might be fine and good if you're talking about just a garden variety county or a city or even a state election. But when you're talking about the presidential election, and there's constitutional deadlines, the slate of electors has to be sent to the Congress, I think, by the middle of December. And of course, the election is in early November. And when the election results aren't known for days or even weeks, there's just no way, is there, Chris, to get a traditional lawsuit done and finished in time to resolve this. So what do you do?
It is incredible. There are incredibly tight timelines. I actually appeared in another Georgia case where I represented the 12th District GOP. And we were, just trying to put that case together in a matter of weeks was difficult. So you've got November 3rd, and then the next milestone is the safe harbor deadline, which is December 8th. And that's when the states are supposed to have resolved all election disputes before the electors cast their votes. And so they have to certify the results by that date. That's December the 8th. So think about it, November 3rd to December 8th, it's barely 30 days to investigate, find witnesses, file your lawsuit. I mean, it's a tight timeline. And then after that, after the December 8th timeline, a week later, the electors cast their votes. And about a week after that, that's when the states send their votes up to Congress, and now Congress has control of it. So you literally have maybe 30 days at the most. And that's as a lawyer, that's little to no time whatsoever to put together a lawsuit. It's a lot of work.
And of course, that's just the law. And then once there's a ruling in a lawsuit or a verdict or a judgment, then somebody gets the right to appeal that. I mean, that's right. That's in the Constitution. So, all right. So we've got a problem sort of baked into this cake here when you have any belief that there's election irregularities. So can you briefly tell us what it is that you think was irregular about the election? Because I'll let you in a little secret. I've been watching some of the court hearings, and I know that you guys had a motion hearing asking for, I guess it was the state, to give you guys every ballot in the state of Georgia. Is that right?
Well, I wanted to have all the ballots that Fulton County had sent to them, because on election night, they're supposed to send up a packet certifying their results. And there was apparently a couple different attempts at certifying the results in Fulton County. And so I started with just Fulton County. Now I branched out. I got more counties in my sights right now. And by the way, I don't necessarily blame the counties. As I told you before, I think the voting systems are just horribly designed. You're expecting, and I don't mean just in a pejorative or a derogatory way, but these people that are running the elections they're not brain surgeons. I'm not a brain surgeon, and if you stuck me in that environment, these are machines. You have to be trained on them. And, one of my problems is that when I learned that Fulton County didn't do any voter signature verification as required by Georgia law.
What? Wait a minute. What?
They didn't do any voter signature verification as required by Georgia law. Not a single one.
How do you know that?
Mark Wingate was the first one. He was on the Fulton County Board of Elections. He's the one who told me initially, and he was so disgusted by it. Plus, I believe he told me that they had 113% turnout of all eligible aged voters in Fulton County. I don't know how you get 113% turnout.
Okay, but so who is Wingate again? He's a member of the Fulton Board of Elections.
He was from, I think, 2017 to 2022 or 23. How
many people are there on that board?
My understanding is there are 5 people, two from each party, and there's the last one is supposed to be an independent.
All right. So Wingate, I understand, he did not vote to, I guess,
certify
the Fulton County results. How many did not? How many of the 5 was he the only one?
No, there were the 2 Republicans on the board voted not to certify because, and Mark would tell you this, They asked questions and nobody would answer them. They just ignored them. And he said, look, can we see the results of the voter signature verification? We were told by some of the election workers that nobody was doing the certification, and we have no evidence that it's been done. We got 2 different counts, or actually 3 counts. You got a machine count 1, a hand recount, and machine count 2. So you got these 3 counts, and none of them match up. Votes appear in the hand count that weren't in the first one. Votes appear in the third one that aren't in the hand count. And so they couldn't even do their audits right. Even the famous case, which your audience may know about, Curling versus Roethlisberger. It's a Georgia case. And one of the experts in there comments, his name is Dr. Philip Stark. He doesn't have a bone in this fight whatsoever. But he said Georgians should not trust that their system is reliable or has any integrity. They shouldn't trust that their vote was counted properly because there's no audit. And he went through Fulton County's problems. And as I look at the problems, they're not just make-believe. And we're not just talking about a failure to verify signatures. We don't have signed poll tapes. I've been asking for all kinds of stuff, and Fulton County has been dragging its feet. I know they're worried. They think that I'm coming after Fulton County. And I told them, if I say this system is a difficult system to operate, your excuse, Fulton County, is that, this was foisted upon you by the Secretary of State, and county after county in Georgia, nothing ran smoothly with these machines. So it's not that the machines themselves are nefarious, right? Not that they're evil. They're just machines, like calculators. But it's the people that are administering them. It's just they made it impossible.
All right. So is this an opinion, or do you know for a fact that Fulton County didn't use the signature verification?
Well, they admitted it in open court. I filed a subpoena, and they said, oh, well, they didn't say we didn't do signature verification. You see, they have this thing called the Blue Crest machine, which takes the absentee ballot envelope, separates it, scans the ballot, and puts the image up of the signature next to an exemplar. And Mark Wingate said it wasn't working, and I confirmed. I said, give me the Blue Crest machine results, and they said, we don't have the ballot scanned. Well, then how did you verify signatures? Simple as that. So
all right, so it sounds to me like you've got 2 out of 5 voted not to certify the Fulton results. So we could have had a completely different. We wouldn't even be here talking necessarily right now about this if you had one more vote that had a question about that. Is that a fair statement?
That is a fair statement.
Because it sounds to me like what you're describing, at least, is things that are matters of opinion. In other words, it may be this member's opinion that that there could be irregularities and he's not comfortable certifying it. Somebody else could have the opinion. Sounds like you have the opinion that the results are not reliable. So when we hear language in an indictment that states things, as a matter of conclusive, gospel fact, how do you square this? I mean, are we prosecuting people based on the utterance or tweeting of an opinion?
Yeah, it's worse than that. I mean, you've heard the old saw that you could get a grand jury to indict a ham sandwich, and it sounds funny and odd to people, but I'll give you just a quick illustration. I think that will seal this for you. Harrison Floyd's been charged in Fulton County with trying to get Ruby Freeman to make a false statement. Now, what is the false statement? I don't know it. I've been in that case now for over 8 months. Harrison Floyd doesn't know what it is. The judge doesn't know what it is. I've been challenging all the prosecutors left and right at every hearing. Give me the false statement. Give me the false statement. And the only thing I got from one of them was, why do you want it? Well, you're charging my client with it. And number 2, what if I want to prove that it's true? What is it that you're claiming he wanted to, that you're claiming that he wanted somebody to say that was false, and they don't have it? And the reason they don't have it is because it doesn't exist. So the grand jury indicted Harrison Floyd on nothing. If I were a prosecutor, I'd be ashamed and embarrassed, because the prosecutor's first job is to do justice, and you know that. It's not to do.
Yeah, we've done lots on that, and that is true. The prosecutor's primary ethical obligation is to do justice, whatever that may look like. So I know that you have filed a motion seeking something that we might call it a more definite statement. In other words, Harrison Floyd is accused of asking, correct me if I'm wrong, Ruby Freeman to make a false statement about the elections in Fulton County, and you have asked the judge to make her tell you what the false statement was. And
no, they don't have. I can't go into the evidence because some of this is allegedly confidential. They claimed it was confidential. But what I can tell you is the conclusion is they don't have a single false statement. I'm not asking the judge for a more definite statement. Let me refer back to a little arcane, an old-fashioned legal term called a demur.
Yep.
And you've got general demurs and special demurs. And general demurs go to the merits of a claim. That is, think of it like a motion to dismiss. And what you say is, I agree with all the facts you've alleged, all the facts that you claim. I don't agree with your conclusions that you think this is a crime. So I don't agree that there's a false statement. That's a conclusion of fact.
Yeah,
but
so that's what I'm saying. It's an opinion, right? If something is false, I mean, unless we're talking about in exact science, like 2 + 2 = 4, right? I mean, at some point, you're on a continuum between things that are provable facts.
We are talking 2 + 2 = 4. They're saying the 4 is the false statement. They just don't have the 2 + the 2. They don't have any false statement, Phil. I can't tell you. I've asked it till I've been blue in the face, and they don't. And I don't understand how I can admit the entire indictment and say, look, I admit the facts in the indictment, but the problem is I didn't admit any facts that show a false statement. So how are you charging him? So there's no false statement.
So he's accused of telling her to make a false statement, and your defense is that it's not false.
No, my defense is I don't know what the false statement is. I don't know if it's false or true yet. You got to to me.
You got to be put on notice, right, of what you're being accused of.
But if they didn't allege that, I maintain it goes to the merits of the indictment and should be dismissed altogether.
Well, I think I agree with that. Now, why do you think the judge, or has he ruled on that motion?
He has not ruled on that one.
That feels like a slam dunk to me.
I'm crossing my fingers because you know how it is. The men and women in black nightgowns will never disappoint you. And I think Judge McAfee, for his age, he's 34 years old. He does have he has this judicial disposition about him where I think he lacks a little depth, but he's getting on his feet. But this is a big case to get on your feet with. Now, I don't think he's going to make the next election because I think he's going to get voted out of office, but that's a function of Fulton County being overwhelmingly.
Well, there are some people who might be cynics who might say that Fani Willis has turned her political machine against him to try to get him off the case.
Yeah, and hell hath no fury. And I think Fani is just so mad. She hates Harrison Floyd. She hates us. I mean, she's accused me of being a racist. She's accused every attorney of being a racist. So you're dealing with somebody who doesn't really care about justice. They care about raising money for their next political event. I mean, look, she tried to revoke his bond, and the day that she tried to revoke his bond, she filed the motion. She was in D.C. at a fundraiser. Now, don't tell me that she wasn't at that fundraiser, claiming that she was going to lock up Harrison Floyd. I guarantee.
You hear that, folks? Willis was in D.C. at a fundraiser the day her office tried to revoke Harrison Floyd's bond and put him back into the bedbug-infested Fulton County Jail.
Now, that's when she filed it. I'm sorry. She actually showed up at the hearing. And when she showed up at the hearing, she had a complete meltdown. She started to lose the argument. I'll give you an example. Gabe Sterling, she called him in to testify because she wanted him to say that Harrison had made threats against Gabe. And Gabe told the truth, and things just started falling apart for her because she didn't like his answers. He wasn't there voluntarily. She forced him to be there. He wouldn't have called the police. He didn't take this as a threat, and so she didn't have all of her ducks lined up. So, but that's you're somebody who's irrational, and now you heard her say the train is coming. I mean, this woman is absolutely hell bent on getting a piece of revenge or vengeance for herself, so which I knew was going to happen if she wasn't disqualified, which that's the other thing. This is where you have a young judge, but you catch 2 people in the bank vault, you send one to prison and you let the other one go. And I don't understand that. I mean, meaning Fani Willis is DQ'd and not DQ'd, but Wade is. It makes no sense to me.
All right. So I want to move. We've been going a while. So before we got to get in what the issue is that you've got on appeal. Because look, I think McAfee's handing out these certificates of immediate review. That's the permission to ask the Court of Appeals, basically, to take the case. He's handing these things out like Halloween candy. So let's get into what's going on with. Thank you, Master Chief. I appreciate it. And by the way, the super chats are always appreciated. As some people in here, I can see you're joking. Yeah, I am actually trying to do some tech and other upgrades. So anything that you do in support of the channel, we certainly appreciate, and that's what it's going for. But we've got almost 1,500 people in here in this live right now watching this. I want to ask every one of you, please, to hit that like button. It won't cost you anything. It'll just take a second, but it certainly helps the channel out quite a bit. So we've got this, we've got your petition for interlocutory appeal. And before we get into that, let me just share one other very short 35-second video related to what we're about to talk about.
Possible obstacle for the trial in the Georgia election interference case involving former President Donald Trump and others. So late this afternoon, Judge Scott McAfee granted co-defendant Harrison Floyd a certificate of immediate review, which clears the path for Floyd to ask the Georgia Court of Appeals to intervene in the case. Now, Floyd's legal team have argued that the charges against him should be dismissed on procedural grounds. Now, McAfee has so far denied those efforts, so today's decision is actually a shift here, and it's up to the appeals court to decide whether to hear Floyd's argument now or wait until after a verdict is reached.
All right. So we've talked about a certificate of immediate review. We've talked about it at length, and go check out our other videos about this. When it's about the appeal, basically the Fani Willis fiasco lands on the steps of the Georgia Court of Appeals. And we've got multiple issues going up on appeal. Yours is one of the latest ones. Of course, the big one that we talked about most recently was the disqualification motion, which, by the way, I think there's going to be a yes. I think they're going to hear that. It only takes one judge to agree to hear it. And if that's the case, if we get one of the three on the panel that it's going to, that thinks this is a worthy issue, then the Court of Appeals will take that issue and address it, and we'll address the merits of the appeal. But you, Chris, you're about a week behind, I guess, that one, and you are asking them to appeal your issue as well. So for those of us who just joined us here recently or missed the very beginning, tell us what this issue is that you are taking up on appeal, because I think it relates to the election board that we were talking about a few minutes ago.
If you go to page 2, I'll spare your audience my nasal voice, but page 2 of that same pleading, I basically set out the issue in just a very short paragraph. And I don't know if you can move to page 2.
I can, but give me just a second. I'm working on it. Here we go. Defendants. No, that's got the citation for contempt.
Well, I'll just read the first paragraph. It doesn't take long, but basically go to the second page right there. Petitioner Floyd has a fundamental right not to be tried if the Fulton County District Attorney's Office lacks jurisdiction to investigate and prosecute the election case. And the issue before the court is whether a local elected district attorney has sole discretion to independently investigate a statewide election and to prosecute election fraud and irregularities without first obtaining a referral from the state election board. I mean, like I said, the statutory scheme, when they set this up, the state doesn't want local passions and prejudices to govern prosecutions. And so you're supposed to have a state body that oversees elections. And so I've quoted all that there, and it's a very short, relatively short notice of appeal. Hopefully they'll take it. But I set out the language that sets up our position.
Yeah, you point out here, you say the legislative structure is straightforward and unambiguous to minimize partisan abuses, fragmentation of investigative activities. And that I think is key. Fragmentation of investigative activities and confusion about the enforcement of election laws. The legislature plainly inserted the SEB into the process, state election board into the process, with the purpose of determining when an investigation or prosecution would be necessary or advisable. So you're talking about fragmentation of investigative activities. And by that, I take it to mean, one DA looking at it in one way and one DA looking at it
Right.
another way, maybe the attorney general having a different idea.
Right.
Because honestly, we have that now. We've got DAs across the state that would say that Fani Willis's indictment of Harrison Floyd and the others is bullshit. They would say it in a heartbeat if they felt they could. And you've got other entities that might have jurisdiction over this that have not seen fit to investigate, but Fani Willis did, simply because she's in Fulton County, presumably. But that's what we talk about. We talk about fragmentation of investigative activities. And
you got 54. You have 54 district attorneys in Georgia, right? I mean, that's 54.
Take your word for it.
Yeah, but I mean, that's the whole purpose of this, is to obtain uniformity, and they say that in the statutory scheme.
Well, and then this talks about, the statute, the Georgia law that you're traveling under. The purpose of it is to determine when any election violations or criminal prosecution would be necessary or advisable. Do you think that's why? See, prosecutors don't need an advisory or grand jury like the one, investigative grand jury like the first one she impaneled, when you had that nitwit, the 4-person that went out, and just went bananas on media and all this. Anyway, they don't need that. They don't need an arrest. They don't need a grand jury indictment before they can just do an arrest warrant to arrest somebody, but they can go straight to a criminal grand jury. But she took the unusual step. Maybe it's because she needed that time to figure out how to pay Nathan Wade, but she went to the extraordinary circumstance of impaneling this investigative grand jury. Is that so she could claim that she had, some entity advising her that these charges were necessary?
No, when I get my other pleadings, I'll send them out to you, and you can put a link for your audience. But she actually wrote a letter to the chief judge where she essentially says that the rest of the state, the Secretary of State and the governor, they're all compromised. I'm the only one left. I'm the only one left standing that can investigate this. That doesn't.
What do you mean by that? Explain that.
I don't know. That's what I'm using her words.
Well, who is she saying was compromised, and in what way?
The Secretary of State's office. She said that they had all been contacted by the defendants, that we were all in cahoots. I mean, that's what clued me into this idea of the SEB. When I came across the statute, I realized she was literally putting the statutory language in her request for a grand jury. And she was basically claiming that everybody else was compromised, including Brad Roethlisberger. Nobody had the power to investigate. Look, the state election board routinely investigates alleged irregularities and refers them out to district attorneys and or to the Attorney General of Georgia. So, her excuse she gave no reason for it, nothing like that. So I think she's improper. I mean, I think what she did was improper, and I think that she's barred from bringing this grand jury indictment.
All right. So this is the essence of your appeal here. You point out that there's very little case law on this particular issue, and none appears to be on point. And there's so many things, Chris, about this case that I think are just absolutely issues of first impression. We've never, for example, had a situation where an elected district attorney was having an affair with a private lawyer who she appointed as a special prosecutor to prosecute a giant RICO case as massive as this one, let alone one on a matter of worldwide public interest, right? There's never been a case like this. And it doesn't surprise me that we don't, because you don't have prosecutors out routinely prosecuting statements of opinion. When you have people that lose elections and they say, hey, I think there's monkey business going on. That's like political speech. That's First Amendment stuff. We don't have prosecutors doing this. And that's why you correctly point out that there's case law on this issue.
Yeah. I mean, the state political, I mean, not just I want your listeners to know that RICO is such a bad law. It should be repealed and buried, never used again. But they're using it to oppress and to suppress political speech. You can be wrong in political speech. It doesn't matter. You can even, I would even venture to say you could be like Joseph Goebbels. You could lie. Now, I don't think any of our people lied, but political speech is subject to the highest scrutiny in the First Amendment. And so that use a criminal case like this, I think, is unprecedented.
Okay, so you refer here to the judge's order saying that a DA has concurrent jurisdiction with the state election board And you say that renders the state law that you're traveling under, or he says that it's superfluous and unnecessary. Explain that.
Okay, so why even have the state election board? Why even have that body if anybody else can prosecute it? And the judge's response was, well, Mr. Kachouroff, how do you know the legislature didn't intend for more eyes to look at it? And he specifically said, maybe the legislature intended the more the merrier. Well, that's not a rule of construction.
So does that mean that every DA that thinks that they want to get involved can just get involved? If you read it the way the judge apparently reads it, and I agree with you, by the way, if you read this the way the judge reads it, then the state election board, as you said, is unnecessary because any DA, the whole reason for the state election board is to make sure that you don't have this patchwork of stuff, enforcement stuff going on around the state, or individual DAs doing something different. If the state election board felt that criminal prosecution was necessary, they can certainly refer it to the appropriate prosecutor, can they not?
That's exactly right. That's exactly right. And that's the way it should be, so that it's not partisan. So it's not seeing what's going on right now, which is you've got a dictator, Fani Willis, who is an abject, and I'll say it on the air in front of your people. She is a Marxist. She was raised by a Black Panther, and somebody who hates anybody that isn't black and leftist. And so she's making good on all her promises. So I don't mean to be too dramatic on your show, Phil, but that's what you're dealing with Fani Willis, and that's specifically what the SEB was designed to avoid, in my opinion.
Well, in fact, you get in, and that's what you get into in the next page here. You got, it shall be the duty of the state election board to investigate or authorize the Secretary of State to investigate, when necessary or advisable, the administration of primary and election laws and frauds and irregularities in primaries and elections, and to report violations of the primary and election laws either to the Attorney General or the appropriate district attorney, who shall be responsible for further investigation and prosecution. I got to ask you, how did you, this is a pretty arcane sort of area of the law. This is not the kind of thing that a lot of people are actively aware of. How did you get turned on to this particular legal issue? And I almost said the word minuscule. It's not minuscule because the impact could be just devastating to Willis's case if you win this appeal. So this is a very important issue, but it's sort of it's very well hidden, right? It's not something that we all learn about in law school. How did you find it?
So I made my career has been built on, I try to do a lot of government litigation.
Okay.
And when I was raised to be a lawyer, I was taught by men that one of them has since passed, who I have a lot of respect for, but he always told me, Chris, there's always two questions. There's the question of right or wrong. That's, everybody knows to argue that question, but the first question really should be, who has the power to decide? And so I always think about the first question in my suits, no matter what kind of suit it is, who has the power to decide and why? And so what I do is I start looking through the Georgia code, and I just start thumbing through pages. And I got a great co-counsel, Todd Harding, and we were talking about this issue, and he said, so I don't think they have jurisdiction. And I went, I'm in agreement, and so that's how that idea popped up. And I don't know how we found it. It is arcane, yes, but when you've got two people that are concerned about the Constitution and about power, government power, these things are at the forefront of what we do.
All right, so we're waiting on the Court of Appeals. Now that you've got this file, the next thing is the Court of Appeals has to decide if they're going to hear it. Do you know if it's going to be the same division of the Court of Appeals? And by that, I mean the same 3-judge panel that's going to hear the other application for interlocutory or pretrial appeal, or do you think it may be a different one, or do you know?
I think it'll probably be the same one. I mean, they're gonna go up together. So okay. I don't know how many judges are on the Court of Appeals in Georgia. Is it?
Oh my gosh, you shouldn't ask. You shouldn't put me on the spot. Is it 15 or 20? 15 or 20? I'm thinking.
I consulted the Oracle.
Yeah. Well, I mean, they're divided up into 3-judge panels, and the way it works is, that one judge of the panel can decide whether or not to hear the appeal, and then if they say yes, then the appeal is heard, and then if 2 judges of the 3 agree with the merits, if you will, of the appeal, then Judge McAfee would be reversed, and then whoever loses, by the way, in the Court of Appeals can ask the Georgia Supreme Court to hear the appeal. But before they can do that, they get to ask for what's called here in the South, we call it an en banc hearing, where it's en banc. It's 2 words, French, ENBANC. Maybe it's Latin, but in any event, it's where you ask the entire Court of Appeals, all 15 of the judges, to do what's called an en banc rehearing with all of the judges instead of just the 3. And if that happens, then you have a new hearing, and then it's majority rules. So there's a lot of things that can happen. And by the way, if the Court of Appeals says no, they're not going to agree to hear your pre-trial appeal, that ruling can also be appealed, it's my understanding, to the Georgia Supreme Court. So we got a lot of stuff, and you do need a whiteboard, I think, to be able to follow this. But there's a lot of grounds here for the appellate process to run its course. Do you agree?
Yeah, there is a lot of grounds to run its course. If I had to predict, I'm going to say that the appellate court doesn't want to touch our issue. It's easy for them to say, oh, well, we got all this law enforcement. Surely everybody has jurisdiction. There's a lot more to our motion and our plea and bar, but you've got the flavor of it with that notice. But I'm expecting that the Supreme Court of Georgia, we have a better shot there because they're textualists. They actually look at the text and really analyze every word. I mean, that's the hard part of lawyering, is you have to look carefully at a statute and make sure that you give every single word a meaning, not the meaning you want it to have, but a true meaning, and so that's what makes that very difficult.
All right. Well, I've kept you here almost an hour and 15 minutes, longer than that, because we were talking beforehand. What else do you want to tell our folks listening, or who may see this later on replay? What is it you want us to know about Harrison Floyd, about the case, about Willis, about any of this stuff?
Well, Harrison's a good man, former Marine. I don't think he did anything wrong in Maryland. I don't think he did anything wrong in Georgia. And this is a political prosecution. I think, we've woken up and we think that, oh, well, we got to save the country. It's gone. We got to take it back. And people like Harrison Floyd and quite frankly, whether you like Trump or not, they're getting the brunt of the political prosecution. Even people on the left are sorry about it. So I would tell your viewers and audience that, you can fight in different ways, contribute to these defendants because they need help. Lawyering isn't easy. Hiring experts, hiring expert witnesses and investigators, all these things take money and time. And I can tell you the lawyers in Harrison's case, we've split up the money between the 2 prosecutions, and we're still raising funds to go after and to do our jobs. But we're here doing it no matter what. And so you can fight in your own way, and at the very minimum, make sure you vote and vote the right way.
All right. So there was a question, and I apologize. There was a question
Right.
a few minutes ago that I didn't want to interrupt you, and someone, I forget who it was, and I apologize to that person. Someone posted a comment asking, why hasn't the state election board spoken up about this? And I thought that would be a good question for you to answer if you have a minute. Don't mind.
Well, I don't think, first of all, they don't have resources to, quote, speak up. I mean, they can't hire an attorney. You got to jump in and represent the board. Remember, a board isn't 1 or 2 people. It's the whole board. The whole board has to act. And so they would have to, somebody asked, is there a way to recoup the costs? Yeah, I wish. The whole board has to act, and they don't have the budget to jump into a case here in Fulton and say, this is our jurisdiction. But interestingly enough, we do have a letter from Governor Kemp where he acknowledges that these issues are within the that he has no jurisdiction to investigate election crimes or irregularities, that is properly the SCB's jurisdiction. So we do have that letter. So, I mean, it's a good question.
So one of the senior chief, let me get back to one of my favorite chatters and members of the channel, retired senior chief petty officer from the submarine service. He's asking, or maybe it's she, I'd hate to be presumptuous, but I'm old enough to remember when only males could serve on submarines. But in any event, Senior Chief is asking, is there a way to recoup the cost? And I'm assuming he's or she is referring to the I guess the costs that are borne by these defendants. And it's worth talking about because look, most people can't really afford to pay lawyers to handle cases that drag on for 15, 10, 5 years, whatever. Okay. And there's a lot of work. And this is the kind of case that can eat up a lawyer's time almost to the exclusion of all other cases. So the cost to get lawyers, just the attorney's fees but you've got expert witnesses, you've got filing fees for appeals, you got all this stuff. How do you recover from this if you're a defendant?
You don't. You suck it up. The juggernaut of the state comes to you. Now, I will tell you this. I know my notice of appeal is a long shot. I think I got the best chance with the Supreme Court of Georgia. We'll see. But if they determine that she doesn't have jurisdiction to act, then I'm going to file a 1983 action or civil rights action against her in the office, against every single one of those prosecutors. And I think that the other defendants would join in.
Does that include Nathan Wade?
All of them.
All right,
all of them.
So this is something I haven't heard. We're breaking news here, folks, right here on Inside the Law. So Harrison Floyd's attorney says that he's interested in pursuing a federal civil rights lawsuit seeking money damages for violation of the constitutional civil rights of Harrison Floyd. And he thinks other defendants might join.
And that's only if that the court finds that she lacked jurisdiction, because there's prosecutorial immunity otherwise.
That's what I was getting. You beat me to it, but that's right. I was going to get into that. You got to get through some hurdles first, right? You've got to establish that she's basically clearly violating the law, and it's without dispute that she's violating the law. And if you get the appellate ruling, then you will have established that clarity.
With all clarity in the world,
that's a federal civil case, and 1983 is the federal code section that we're traveling under, and that's where you can seek monetary damages. Is there anything else you can get damage wise for a 1983 claim?
You can probably get an injunction, not to do this again, but that's, in this case, Fulton County's responsible as well. They gave her another $5 million. Remember, she testified said to somebody said, well, how much more is this going to cost? And her response was, Lady Justice has no price. That's because, she wants to advance her agenda. But, Fulton County would be complicit in this. So.
Well, I tell you, there's nothing like this case that I've ever seen. I never would have dreamed in a million years that we'd have this, kind of case pending anywhere in America, but certainly not here in Georgia, which is my home and in my backyard, literally. But, this is something obviously that we're all watching. And, for what it's worth, you say you think that your appeal may be a long shot. I don't think so. I think if you're a textualist, and I tend to be one, if you read the actual text of the law that applies to this thing and the statute, I guess maybe Judge McAfee maybe isn't so much of a textualist, but the way I see it, under the text of the statute, your argument is the winner, because the election board has to give a prosecutor, has to delegate that authority, if you will, and make a referral before anybody can bring the election. I think it's clear. It ought to be clear to anybody who reads the statute. That's my opinion. I welcome yours.
Yeah, I agree. But like I told you, the men and women in black nightgowns will not fail to disappoint you. So,
well, all right. So I'll give you just sort of a preview. One thing I'm working on, look forward to, my friend Julie Hamill's a lawyer out in California. Many of you may follow her on X or whatever. She's going to come on. She's going to join me. We're going to have a big discussion, and maybe you can join us too, Chris, about the fact that we can't count on courts to ever do the right thing. When I first started practicing law, I thought you could. Fast forward to today, I know that you can't. And even when you do eke out a win, it's like pulling teeth to get it. And oftentimes your clients are bankrupt by the time they get there. And maybe they've already gone to jail as well. But I have given up on having courts do the right thing to correct legal wrongs that we see happening in the system.
Phil, you couldn't be more right. And I don't want to take up more time, but if these people think the court are gatekeepers and they're somehow protectors of their rights, they couldn't be more wrong. That's why I always tell people your best bet is to get your legislature, get active with your local legislature and get them to pass laws that assist you. But
well, Chris, I'm gonna let you go, and then I'll finish up with my listeners and viewers. Thank you so much for your time. We really appreciate it, and hope you'll come back.
Yes, I will. Thank you all for listening. So take care.
All right, folks, there you have it. I tell you, there's nobody that knows the inside and out, the intricacies of this case like that lawyer right there. I mean, obviously, there's some very, very good lawyers we've seen representing some of these defendants in this case. In fact, almost all of them are just brilliant. Not to Ashley Merchant, not to mention, and Steve Sadow, of course, President Trump's attorney. Chris is one of the most intellectual lawyers I've ever talked to. I did not know him until the night that his client got a bond, and we were introduced through third parties, and we've been professional friends and making friends ever since. He's one of the most well-read, I think, smart lawyers that is doing anything with this case. And his motion is not frivolous. He's being, I think, I don't know, he's being modest, but he certainly would not have filed this if he didn't think that there was some merit to it. I think there is, but we certainly have a lot going on in this case. I want to thank all of you. We have 1,400 people in here right now. If you haven't already done it, please hit the like button. It won't cost you a dime. We really appreciate it. And it allows other people to be able to find this content. This is obviously, this may not be for everybody, but there's a lot of people who want to know what's going on in this case, and we want to hear about it from the insiders. We want to be able to bring you this case from the inside out, and that's sort of the whole purpose of the channel, is to bring people inside the real justice system, the real court system, the one that I know because I've lived in it for 30 years. And it's not necessarily, in fact, it's not ever really the case or the system that you grew up seeing and reading about and seeing on TV or seeing in the movies. That's fake. That's fake. This stuff is real. When you hear Chris tell you about his client is going to be destitute and bankrupt because even if he wins this case, he's not lying. That's the real truth. It's not, and sometimes it's just not pretty. It's just, it's devastating to people who are wrongful convictions happen, wrongful indictments occur. And I'm not saying all prosecutors are bad. Certainly they're not. In fact, more often than not, prosecutors want to do the right thing. They want to bring legitimate charges. They don't want to have conflicts of interest. They try to follow the rules, but that's not always the case. So what we're going to do is we're going on this channel to look at the things that cause the system to go wrong and to go in the wrong direction. And I thank every one of you for being here tonight. Every one of you for watching and listening and subscribing and all the stuff. And I appreciate the super chats. I appreciate the members, and we look forward to bringing you guys some additional content on this, but also on other legal issues that are in the news. And so with that, I'll say good night and thanks again, everybody.